Hey, everybody, and welcome back to the Legal Weekly Wine, where we discuss the week's hottest legal topics. It is hot. Truly, it is about 98 degrees here where we live. It is the third full week in June that we're discussing the court cases and the issues that have come up. So not only is the temperature hot, but the cases are hot. The Supreme Court has just dropped another, 5 or 7? Is that right, Dr. Weil? This week alone?
5 or 6 today.
5 or 6?
3 or 4 yesterday.
Yeah, so we have a ton of decisions that just dropped this Thursday
Mostly
and Friday.
nothing burgers. I hate to tell you.
Which is hilarious that you say it that way. You're a constitutional law scholar and you're calling them nothing burgers.
Well, compared to the ones that still need to be resolved, they like to keep us on the edge of our seats. I'd like to take a vacation, but I can't.
Yeah, I do know that for people who don't know Dr. Weil very well, he really does plan any vacations he takes around the Supreme Court terms and these decisions. So he is, while the rest of us, or the rest of some of us, are going on vacation, sitting by the pool, Dr. Weil's sitting by his computer, anxiously awaiting for these decisions to come down. And we're still waiting on the presidential immunity question.
Yes, we are. And we're waiting on the power of federal agencies. We're waiting on a couple social media cases. We're waiting on a case as to whether you can prevent poor people from sleeping under bridges. Yeah. And there's a great EPA case dealing with federal regulation of interstate pollution.
Goodness. So that's what we're waiting on. This week we have a few good ones. I think they're good and interesting. A few of the cases, but they're still informational. The ones we're going to hit today, we're going to talk about the Second Amendment case as to whether those charged with and or convicted or have a protective order against them for domestic violence as a parent or a romantic partner, whether that is constitutional, that they are prohibited from having firearms if they have had that conviction or protective order. That was one of the cases that's been addressed. Another one, there's an immigration case out there. We're not going to talk very much about it. We'll mention it in passing. There is a great evidence case, kind of a criminal law case, but it's really evidentiary based on the Confrontation Clause. We are going to talk about that one. Dr. Weil will sprinkle another few in there. But in addition to these Supreme Court decisions, this is another monumental week because we have the state of Louisiana actually passing a law to require the 10 Commandments in its classrooms. We're definitely going to talk about that. We can't pass that up. That's huge this week. So we're going to talk about that, the implications, whether we think it's going to pass muster and when it's going to be reviewed by the Supreme Court. And the final thing we want to throw in there today is the question as to whether Jack Smith's appointment as a federal special prosecutor is actually allowed, because this is a claim that the judge in Trump's federal case in Florida, the documents case, is now proposing. So all of these topics are what we're going to discuss. I'm Virginia Tarani. I am the founder and owner of Tarani Law, LLC, as well as the CEO of The Law Unscripted, which hosts this podcast, as well as other free resources and many law school exam and bar exam prep courses on the core 8 subjects. So a lot of that comes into play. If you want extra help with these subjects, especially if you're taking the bar exam, check out thelawunscripted.com. We have piecemeal all the way down to the very small outline for a class, all the way up to a full program for all 8 subjects. My colleague in both The Law Unscripted and Tarani Law is Chelsea Rogers. It's good to have you, Chelsea.
I'm glad to be here. I'm excited to talk about the cases we have this week.
Yeah, I think I'm most comfortable with the Confrontation Clause issue as a trial attorney. The others are like, oh, okay. But Dr. Weil, I know these hit closer to home for you in terms of your constitutional law leanings. We're privileged to have you, an expert on the Constitution, the amending process, the constitutional founding, constitutional law, and American symbols. So this has got to be exciting, right?
It is, yes.
Okay.
Again, not as exciting as next week. Stay tuned Wednesday, Thursday, and Friday, and you have to do it while you're getting ready for the debates, presidential debates
That's
next
true.
Thursday night.
Next Thursday, this coming
Yes.
Thursday.
Yes.
Mm-hmm.
And so Wednesday, Thursday, Friday, why are you saying those are more exciting?
Well, usually the court has been issuing decisions on Thursday and Friday. It looks like they've also set next Wednesday as a date to release opinions.
Okay.
And typically they release them all either the last week in June, sometimes they go as far as the first week in July, but chances are we're going to get most of what we need by the end of next week.
I hope at least a big one or two. I mean, even this presidential immunity one, if they drop that on Wednesday before the debate, I think that would be huge.
They have the opportunity to do the funniest thing here and do exactly that.
Well,
That's wild.
there's a related case which deals with a lot of the people that have been convicted for January 6th have been convicted on obstruction charges.
Right.
And the question, as I understand it, that law originally primarily seemed to pertain to documents, which are fairly far removed from the actual facts of the January 6th case. And so it'll be interesting, if they were to throw out, particularly a day before or the day of a debate, they would throw out half of those convictions. And that would be a major development.
Correct. And in addition to the convictions that have already been done for those cases, there's the pending charges for the same statute that have been alleged against Trump in the D.C. federal case.
That's right.
So, I mean, depending on their sense of drama, the most interesting piece would be for them to drop those two cases, especially for presidential immunity and the question of, is this statute constitutional? Can it be preceded? Can all these people be convicted under the statute for obstruction?
I can't help but wonder about the timing. My assumption is that they've saved the most difficult perhaps to the end, but the presidential, this is the earliest presidential debate we've ever had.
Yes.
Other than 1859, I suppose, or 1858.
Because
the Lincoln Douglas debates, which actually preceded the presidential election of that year. But they're the earliest in the season. And I suspect that they really didn't take account of it when they did it, because you really would not want probably a Supreme, that would be a reason in my judgment for withholding the cases that I most want to hear till next Friday after the debate. But we will see.
Yeah, it's interesting because the court's not supposed to be political, but don't you see a little bit of maneuvering in the timeline of these cases?
Well, again, it's not unusual to save the most important cases, most controversial, to the very end. So I don't think they're particularly departing from norms in that respect.
Okay, well, we will stay tuned, but let's talk about this week's. And before we begin, this, it's happy hour for us. We've grabbed some glasses of wine. Dr. Vile, we're going to start with you. You're anxiously about to hold up. Is it a Pepsi or is it water today?
No, I've already had my Pepsi for the day. And I went to the dentist, so I probably need to cut back on the Pepsis. Stick with the water.
All right. So wonderful water. Now, Chelsea, this is exciting for us. This is the first time that I understand we've had someone gift us some wine specifically for the program.
Yes, I'm so excited. I bet you guys were, waiting for me to hold up my box wine again this week. We're not. We have been upgraded. And so I want to shout out the bottle shop here in Columbus, Georgia. And I really appreciate them. And I'm super excited. Got a couple different bottles of wines. The one I picked today is called, and I've already poured a glass, but I haven't tried it yet. Called Jolene. It's a semi-sparkling rosé.
It's pretty.
Smells delicious. It's really a pretty color. You can see my glass. I've not tried it yet. So I'm pumped and I'm so thankful that they did this. And look at me getting upgraded. No more Aldi wine, guys.
I'm so excited. And thank you to the owner of this shop who decided to contribute. It's really amazing. We love that you're being a part of the show, and specifically in this way. I'm interested to see what you have to say about the wine, because Chelsea, you are famous for the sweet wines. You really like the Moscato, and I'm afraid if this isn't as sweet, you just won't like it.
Okay, I think it's going to be, this is my prediction, again, have not. I think it's going to be kind of sweet, but I think it will have more complex flavors, there we go, than the grocery store
I bet it has
Moscato.
peach in it.
Ooh.
Oh, I bet it does. Let's
It
see.
is Georgia.
Yes.
Fair enough. What are you drinking, Virginia?
So last week we did a wine called Truth. And the funny, if you all remember it, I said, well, if anybody finds a wine called Lies and Lies, send that to me. My husband has found one. We don't have it in our little hands right now, but we have ordered one called Lies because you just have to. But this week, I have another white. It is from Portugal, and it's Estevino Verde. So we're going to try that. It's so hot that honestly, if I just had a hose going in the background, I'm really surprised you're not seeing that. So we're going to try some cool white wine. And cheers, everyone. And Chelsea, we're waiting with bated breath.
Okay, let's cheers. Oh, I really like that.
Do you?
This is so good. Yes, it is really sweet still. Not as sweet as Moscato. And I like that it's like semi-sparkling, get a little like tingles, the bubbles. I do like that. That's good.
Okay. Well, excellent. So I'll have to try it too. Tell your owner thank you, and
I will.
We will drop his information in the bottom to let you all know where to get it and who he is and that he's supporting us. So thank you again for that. Okay, Dr. Vile, let's start with, you want to do this? Let's do the Second Amendment. Let's start with that. As the Constitution scholar and constitutional law scholar, we've got truly the Second Amendment, which you hear that, you hear guns, you hear NRA, I hear, how many controversies, we hear Confederate flag, we hear Trump. There's so many terms and phrases and names now associated with this amendment. But let's go back to the basics. What ultimately and basically does that amendment say?
What's fascinating about the Second Amendment is when I started, how many years ago in constitutional law, there was one case that was cited from the 1930s, which basically said Supreme Court can regulate machine guns or sawed-off shotguns, it might have even been. And it wasn't until basically 70s or 80s that sort of interest sort of redeveloped. The problem with the Second Amendment is trying to figure out, it has an opening phrase. And what is it? Security of a free state. Or militia.
If you don't know, I don't know. I'm going to have to pull it out and read it.
Got a pocket constitution to whip out.
Let's find it. It's embarrassing. But it has one of those phrases that you can't figure. A well-regulated militia being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed. So for a long time, the amendment was interpreted basically as the right of state militias, people in the state militia. And then people said, no, right to keep and bear arms, if there's any right that's essential to human beings, it's self-protection. Go back to Thomas Hobbes' State of Nature, John Locke, all life, liberty, pursuit of happiness. And so it became interpreted in a more individualized way.
Versus an organizational way. Versus a government protector then becomes also individual.
Right. In other words, it's not just a right that you have if you're a member of the militia, it's a right that you have as an individual. And, it was interesting. I was in Hungary 2 or 3 weeks ago, and I asked a friend of yours, actually, if I recall correctly, whether Hungary had a right to bear arms. And he said something to the effect, yes, we lived under communism long enough to realize that people needed the right to protect themselves.
Wow.
And that's, counter to many Western European nations. New Zealand is famous for practically outlawing all uses of guns. And we have among the more liberal gun regulations in the country. But 2 or 3 years ago, New York State Rifle Association versus Bruin, the court issued an opinion basically saying New York had a law that basically said you can have a right to bear arms if you show sufficient reason why you need it.
Right.
And this guy says, well, my sufficient reason is I'm a citizen of the United States and I'm covered by the Second Amendment. I shouldn't need a special reason to carry a gun.
Right.
And the court agreed. And so they open the lid probably as widely as it's been open. And this current decision has to do with a person who is under, I guess there's been an order, an injunction against him. There's probably a better term for
Protective order.
Yeah, protective order. I mean, it's the worst case I can think of if you were an attorney. The guy, if you read the record, the guy is in several different times he's shot into the air or shot at a passing car or whatever, and he's also threatened his wife, and there's a small child there. And the court, in New York State Rifle, the court essentially said, you know, the only regulations we're going to accept are those that are based in history. And this person, Rahimi, I believe his name is, I may be mispronouncing it, he basically says there's not an analog in early American history that keeps, or there's not an identical, there's not a twin is actually the term that he uses. There's not a twin regulation prohibiting individuals who have threatened their wives and children from carrying guns.
Right.
And the majority, I think, wisely says, well, there's not a twin, but there are two analogs. And one is there's a law that you could require a person who seemed to be out of control to post a bond saying they would not misuse the gun, and if they did, they'd forfeit the bond. And then there was another law that basically said if people ride around the neighborhood threatening people, you can get an injunction against them.
But basically, in either case, the idea was that they impose a threat, that there's some sort of threat by having a weapon, by using a weapon. They're doing it to inflict harm or potentially threaten other people. So the idea, I think, behind it is this preservation of other people.
Right.
Right.
I mean, it basically, and the court had said this earlier. You know, Scalia was the one, if I recall, who wrote the major Supreme Court decision dealing with the right to bear arms. But in that decision, they had indicated that no more than any other right in the Constitution is the right to bear arms absolute. You know, if you can't falsely shout fire in a theater for fear of causing panic, then certainly you don't have a right to wave a gun around. And this decision essentially said, you know, you have a broad right to carry a gun. They actually struck down a law that said the court can strike down, the court can take a gun from anyone who doesn't have a reasonable, I forget what the exact term is, but a specific reason for having it. The court says that's too vague.
Right.
That's too much like the New York law that we struck down. But in the case of, you know, what would be imagine being married to someone or having a father, you know, or a parent that you know, was waving a gun around at you. That doesn't seem like something that a civilized society should. And what's interesting about the case, now there are a lot of concurrences, but there's only one dissent, Justice Thomas.
It was an 8-1 decision.
Which is so weird.
To be, not 8-1. Which means there's not really a conservative liberal split on this, other than Thomas does seem to want a twin, you know, his idea of historical precedent is something that's exactly on target as opposed to something that is what the court calls analogous, similar to, but not identical to. And he seems to be saying, no, you can't find a law particularly, especially dealing with this kind of regulation, then it's not acceptable.
Yeah,
I think the court got it right in this case.
And I like that because it's an 8-1 decision with it's the one dissent. It seems so much less political because there's not a division among party lines, among, you know, party affiliations on the court where we're saying, oh, it's a conservative court. Well, if that many from across the board and the dissenter is a conservative, in my mind, it gives extra weight to the opinion. versus these very close 5-4 decisions, or the 5 with the however many we had dissenting and concurring with A, B, and 3, as of last week that we were talking about. But in this sense, it seems like they opened up that lid, like you said, Dr. Viles, so far before, but now they're saying there are still some limitations. It's not so broad as to allow anyone and everyone to have a gun. But Chelsea, before we were on here, I want you to share some of your thoughts about what would have happened, if it went the other way. What does that do to the other laws we have regarding firearms, federal or state?
This was my first thought. And we were talking about it off air, especially because you've talked to me a lot about your experience as a prosecutor and especially dealing with like guns and drugs. And it's funny because so many people who are committing bigger crimes get caught by doing a littler crime. And that's how it happens. And like felon in possession is one of them we talk about all the time. And so if this had gone the other way, that wouldn't be a thing anymore. For lack of a better term, like that would not be allowed to be a punishment, essentially, or a law. Which is a wild thought to me.
Yeah.
I mean, that's a real literal interpretation of a document from hundreds of years ago. That's really literal.
Yeah, I mean, if we're looking at literal interpretation, I mean, we don't have muskets anymore. Are we looking for, you can't have a musket if, and
we
now
have
we
militias still? Like
right.
state-regulated militias, the National Guard? I don't know.
Yeah, so I think there has to be some breathing room, right? There are, and what the court was expressing is there are changes. We can't stay back in the original founding documents in that time frame where we have only the same limitations on weapons. So we can't keep the same language, and we can't expect them to have these twins. They have to be something similar, the same intent behind it. But there can't be, there is always evolution on it, for good or bad. You can say, the nuclear bomb's been created. Would they have ever thought of that before? No. So in my mind, I think it is, like Dr. Viles, you're saying, it's an appropriate analogy and use of.
A number of the justices refer to common sense, and I don't know that is a necessary, method of constitutional interpretation, but I don't think it should ever be left behind. And again, partly this is a really bad case in terms of the person bringing it. There's just so many strikes against, he's just, if half the testimony is to be believed, he has misused guns so many times. If there's anybody who shouldn't have a gun, it would be him. And, it's worth knowing that most of the judges who decide these decisions are in courthouses where people have to go through metal detectors.
Yes.
Yeah.
So that is a restriction on gun use. We have similar facilities at airports. And I don't know too many people who want to claim that you have the right, and don't go to Turks and Caicos and leave a spare bullet in your you'll find out that they're even less tolerant of it than we are.
Yeah, and I do think that's appropriate. I mean, schools are implementing security as well. You're not supposed to bring them within so many feet of schools, et cetera, because there is this threat of violence is real. And like you're saying, the petitioner here, can there be any more clear-cut case? Because in my mind, it would have been a harder question, and I'm waiting to see, will there be a follow-up case? Let's take away domestic violence. Let's step outside of gun use. Let's find a case where someone is a convicted felon for larceny. No use of a gun, just the amount that they took was so valuable as to push it into felony range, and they're being denied a gun because they're a felon. There's the, prohibition against felons carrying firearms. Where's that case? That's the one I think will be harder.
Firearms,
right, where there's no
aggravation of penalties.
Let's look at Trump. There's no gun allegation in his cases, but now that he's a convicted felon in New York, those statutes start kicking in, and he is not allowed to have a firearm. So in my mind, that's where the next question is going to be that I think the Supreme Court may have to ultimately decide is when there's no implication of a gun having been used before, especially by this individual in any portion of a case where he's convicted.
No violence, no threat of violence.
is that the next question? And in my mind, I think it would be. I'm not the attorney to take that to the Supreme Court. But if we're looking for what I think would be a better test case where it wouldn't be as obvious, well, of course, we don't want that person having a gun. Well, what about these other felons? Just because you're a felon, does that mean you can't have a gun? Or is there a question of, is it a crime involving violence?
I think in this case, actually, and I'd have to reread it. I read it fairly quickly this morning. But there was an indication that it may not be a permanent bar, that it was only so long as this order was in effect.
Correct. And that is with protective orders. Most states, as I understand, at least the ones we practice in, it's, for as long as the protective order is in place.
Right.
Yes.
But if it's a felony conviction, then the gun's gone. You have no right to firearm. But in this particular person's case, you're absolutely right. We weren't looking at a conviction. We were looking at a protective order, which is a civil remedy against a threat of possible violence, where, yes, there was violence used, but are we going to be delving into, well, was a gun used? Was any violence used? And we can go down the rabbit hole in that type of thing, where right now it's very clean. The distinction is very clean. If you have been found, you're right, there's that phrase in there, and I don't know if either one of you, I should have printed out that phrase and highlighted it, but it's something about reasonable certainty of violence, or there was a specific phrase that I really liked.
I know the phrase you're
If I can
about.
read the holding.
Please.
Yes.
When an individual has been found by a court to pose a credible threat to the physical safety of another, that individual may be temporarily disbarred, consistent with the Second Amendment. So in that respect, it's a relatively narrow decision.
It is.
Yeah. And they're not saying they have to be. They're leaving it up to the states to put something like this in place to even give these protective orders more teeth.
Mm-hmm. And it's saying not conviction, it's saying credible. Right? Credible evidence. So in this case, because it's a civil order, then the evidence was credible. Now, the question is, what amounts to credibility? Is it enough for a civil preponderance?
Let me ask you this. Do you want to be the judge who decides that somebody has the right to have a gun after they threaten a spouse and they go home and kill them?
No.
I mean, that's
not at all.
Part of what...
I also wonder, though, especially in these cases where we have family violence or domestic violence. Okay, what happens when there's some sort of altercation, the police are called, there's not a lot of clarity as who is the aggressor and who is the victim, and there are two guns owned by each of the people. Are we taking both?
Yes.
Because then, like, what are you doing if you take one and not the other? And that seems stressful.
Right. It is. It's a hard one, and as I have so many colleagues and friends who are law enforcement. Even my husband was a police officer, and there's a common consistent theme of the two most dangerous types of cases they ever respond to are domestic violence and traffic. Mm-hmm. And so putting a gun in, yes, somebody's always going to have a knife. We all have access to kitchen knives, et cetera. But that gun adds just that extra level. So I think this was a really interesting, clarifying question before the Supreme Court. Thanks for stating the specific holdings so that we could have that language. Now let's jump over to one that I find a little more fun because I'm so much involved with trial work, is this evidence question of the Confrontation Clause. Dr. Weil, what is this Confrontation Clause?
It's a provision in the Sixth Amendment that basically says that you have the right to be confronted with witnesses against you. And that's been a little bit more broadly interpreted to say that you or your attorney have the right to cross-examine such witnesses. And most people know there's a prohibition against hearsay, which are out-of-court statements asserted for the truth of the matter. And this is a sort of a fascinating case, and it would probably make a good law review article because it sounds like something in the background here that we don't know. Because someone is doing DNA test, and suddenly she, I believe, disappears from the scene, and somebody else from the company says, well, here's the evidence, here's how she interpreted the evidence that they had.
I agree.
And the court said you're relying on her initial finding as truthful. And, you can't help but wonder, was she fired because of we don't know that.
Right.
But could she have been fired because of some kind of irregularity in the processes that she used? She had found several different illegal drugs. And so this person was being tried for possession and, I don't know, distribution. But
I think it was drug analysis versus DNA, but
right.
Yeah. So
Right.
Chelsea, I know you and I have talked a lot with our law unscripted courses.
Yes.
We went through our evidence classes. We have those. And there's this case of Crawford versus Washington, testimonial hearsay, confrontation clause. Is there a way we can better fit this into a more manageable understanding of what in the world is allowed and not?
I think that's the hardest question you've ever asked me, Bridget. Let's start there.
Sorry.
No, I mean, I really think it is, especially when I really don't even know how to answer that, because for me, when I think of hearsay normally, I don't think of the hearsay exceptions that we're talking about, like business records, or we have these lab reports. I feel like those are not usually the issues that came up much, especially in any of my trial classes. And so this seems like out of left field. I don't know. I don't have a good answer for that one.
That's fair enough. And this is, I think, one of the reasons this is a significant opinion is it isn't as cut and clear or clear cut. It seems a little more complex of what in the world. And we've got this phrase that the court continues to use of testimonial evidence. I'm like, well, isn't all evidence testimonial? I mean, they're giving testimony. Is it
not testimonial in nature?
I think the distinction is between that and physical evidence, right?
It's not,
like
actually. It's not. It's not. The testimonial evidence, when we're looking at testimony versus testimonial evidence. So in hearsay, you cannot admit hearsay statements made out of court for the truth of the matter into court. You're not allowed to. But there's this question of, well, if it was out of court, but it wasn't instigated or started in anticipation of litigation, then maybe it can get in. It doesn't affect the
under an
confrontation
exception
clause.
Is it present sense impression? Is it
dying declaration?
Dying declaration. Excited utterance, my favorite. Like when you just can't control the things coming out of your mouth. They can.
Right.
But
Whereas
if you said it
report
outside of court for the purpose of having it brought up in court, we're like, yeah, no, that we're not doing this.
Yes, and that's brought up under this special term, testimonial hearsay. And with that, so a police report is a classic example of testimonial hearsay, is you're not writing a police report except for the idea that something has happened, usually a crime has been committed, you are investigating it, and you are writing it up for potential use in court. So because it's written in anticipation of litigation, that physical evidence, it's written, is in anticipation of litigation. Lab reports.
Shocking. I was going to say, can we talk about that for a second? This was shocking to me to learn in law school that police reports were not admissible evidence. That was like, I couldn't wrap my mind around that. I was like, what do you mean? Isn't that the whole point of it? And they were like, yeah, no, you can't just admit that document. And I was like, but why? And I'm like, well, it's hearsay. And I was like, okay, now that you mention it, true. But like, I think everyone just assumes that a police report is admissible because it's for the purposes of being in court.
Police officer in and ask about the report.
Yes.
Right?
And that's where the confrontation clause comes in, is you can have the police officer testify
but he has to be able to be cross-examined.
Yes, where you can't just submit a report and the report can't be cross-examined. It was someone's thoughts and writings outside of the presence of the court and the jury. And in this particular case before the Supreme Court, what we're getting is the defendant says, look, okay, you have an expert up there. Great. But that expert that you have testifying as to the findings is not the expert that made the findings.
Is not testing the evidence. They are reading a report of the lab tech, essentially.
Right. And we've had prior cases that say, okay, you can't just come in and read the report because that's someone else's opinion completely. But in this case, the prosecution went a different way where they're saying, okay, we're not just admitting the report. We're not just entering it without the witness who prepared it and did the testing. But what we're going to do is have her colleague review her report all of her findings, all of her process, and come in and testify to it. And we're not even going to say that those are his conclusions. We're going to have him admit that, yes, my colleague did this, and here's what she found, and I agree. Put that stamp and seal of approval on it. And the court here has said, you're really sneaking this in. You're saying it's his opinion and you're submitting his expert opinion, but what you're really doing is you're giving credibility to somebody else's opinion who cannot be cross-examined.
And I think that makes sense because that's essentially, right, like what they're doing is very sneaky, I think. So, I mean, I think it's smart because they didn't say you couldn't do it. So, I mean, I think they were very creative here, but it's saying that, like, this is my job and I didn't do this particular task, but here I'm explaining to you the standard operating procedures. And I am just saying that because that's standard operating procedure, she definitely did it. And that's why these are reliable. But
right. This is cocaine. This is meth. Well, that's nice. And it's hard because as a former prosecutor, I'm thinking of all the turnover we had. If a forensic scientist, pathologist, whoever they left, we had one coroner who died. And what do you do with all of those?
Dies, but can you not subpoena her even if she has left this company? Because to me, the red flag here is like that person is so not credible that I cannot put them on the stand to be cross-examined because once they do, this report will mean nothing.
And I think that's the ultimate question of Dr. Weil. What you're asking is, what do we not know? And I'll say when I was in Newport News, we had, there was a really big case. It was our only capital case. And the main forensic scientist who had gone in and collected blood samples from this quadruple killing and who was able to test and say, oh, wow, the defendant's blood and DNA is in this same blood sample from his son, his daughter, all of these others where you could connect that the defendant was probably the one using the knife. That person moved across the continent. It wasn't even to Indiana. This person moved overseas. And I remember the angst we had of we can't subpoena this person. She moved, her husband got a different job overseas. She's all the way out in wherever it was. We can't subpoena her to get here, but we can't let a murderer go free, right? I mean, drugs seem a little bit different, but yeah, I appreciate the idea of the prosecution of we can't let this happen just because someone's not here. And ultimately, what the Supreme Court is saying that the Confrontation Clause says, yes, you can still admit such a report if there was prior testimony under cross-examination. So if there had been a prior trial, a preliminary hearing, where this person had recited their report, had been questioned on it, then yes, it can still come in. Because
I don't know the answer to this. Can I ask a question?
Yes.
Will that include a deposition?
It can. If the witness, and this is where we get into the evidentiary and confrontation rules too, is if it's unavailable, if the witness is unavailable, right? So with hearsay,
this is what I'm thinking. Yes. Okay.
Non-hearsay, which Dr. Weil, you're so good at teaching in mock trial of if it's not for the truth of the matter, then it's not a hearsay statement. If you're saying, well, I wonder what the weather will be, well, there's no truth to that, right? It's a question. There's no ultimate truth. Yeah. Whereas if there is a statement offered for the truth, if the witness is unavailable, there are some exceptions where that can still get in, like the dying declaration. The person died in believing they were dying. They made certain statements, which we decide these are more credible. We will give more credibility to a person who's dying. Why would they lie?
Because we think they're going to somehow, I think that, again, I have so many feelings about the rules of evidence, which is probably the nerdiest thing I've ever said out loud. That is a wild statement. But the idea that, that's not based on, any study saying people are more truthful the closer they are to death, right? That idea is just, the people who wrote the rules of evidence being like, I feel like you wouldn't lie if you were dying. It's the vibes. And we based a whole rule off of that. That is a crazy way to operate, I feel like.
And it can be, but ultimately that's what we're saying is there should be enough truth, whether it's the vibes or whatever. That's now in our rules and our basics. But if a witness is unavailable, so there's, dying declarant, there are other reasons of if the witness is unavailable, and you have to first prove that they're unavailable. And not because they just didn't want to be there or because they were subpoenaed, you didn't subpoena them like you were suggesting, is why don't you just subpoena them? So there's some reason. It doesn't seem to be a question as to whether this analyst was available. Everyone seems to conclude that this person was not available. And the bigger question wasn't, was she or was she not available to testify, but assuming she was unavailable, does this report and her findings, does it fit within an exception for an unavailable witness? And they were like, look, if she wasn't previously cross-examined on it, then no, it doesn't fit, however wonderful a report it was. So it would have to be where the expert, if there's any sample left, this means that they get the new expert to run more samples, run more tests. If it was all consumed in the one test that they already did, well, they're out of luck. But I think that's the ultimate implication is you can't just talk about somebody else's work unless it was previously testified to under oath and under cross-examination, either prior in the trial, like a prosecution witness who then a defense expert questions, or another trial.
I have a question for you, Virginia, about this, because this seems very specific, and you had experience working as a prosecutor. How often do you think situations like this are occurring and this would be an issue? Do you think this is going to be a common problem that people are going to see a lot of? Because like you were saying, there is a lot of turnover in sort of maybe these like testing companies. Do you think this is going to be a common issue or no, not really?
I think it's more common than we anticipated. As a prosecutor, I remember, prosecutors are a dime a dozen. How many, you churn through prosecutors and public defenders especially. But even within the science fields, they are also overworked and overburdened within the state system and federal system versus a private company who can charge oodles of money for a test. So I think there is a lot of turnover, even within, like I was saying, we had one case where the coroner died. And what do? Do you really want to dig the body back up? There are certain times where just the reality is that I would say maybe at least a good 10%. Maybe not. That seems in my head based on my own experience for 18 years as a criminal defense and a prosecutor in both roles of it does happen a substantial amount of time where this will be relevant, where it will affect more than just a random case. It will not be just the one-off thing is how many people do leave the field and they don't want to come back. They don't want to testify. They move somewhere else. They can't be subpoenaed. And I think it, in a way, if I were the head of one of those departments, my question for people coming in would be, before we hire you, do you understand how serious your work is? And that it implicates multiple criminal trials. Even if it's drugs, it's, these are crimes that you're investigating. And if you leave, then you are leaving potential cases,
maybe there'll be an employment contracts for these type of agencies that even if you leave before the term of your employment contract is up, you will be available for this purpose. I think that might be something we see getting put into the hiring process.
I think it would be a good idea. Now, it's hard because it's
not going to be enforceable, right? But at least you're saying, hey, I'm flagging it.
But maybe it is, and maybe it becomes one of those questions that you ask an applicant, because the reality is cases in any of the legal systems, civil or criminal, take how many years to complete? These are not quick turnarounds. You don't go to a crime scene today and testify tomorrow. These are sometimes years in the making, and by the time it gets to this case in the court, you may be out in China. We don't know. So I think it's forcing a prosecution and those offices to look and say, okay, what's our next plan? Do we have a plan B that is not just throwing someone up there to read the report? Because now we have to. And in a way, you and I were talking earlier today about preparedness. I think this is going to change the game of being prepared and what that looks like in a criminal prosecution.
Yeah, I'm wondering if prosecutors' offices are going to start after they get a result, like the minute they get a result from a technician, contacting the defense attorney and saying, we would like to depose this person immediately. And scheduling that, even though the trial might not be for a significant portion of time, just to make sure that they are able to introduce it later.
I think you've got a great point there. And even if it's not immediately, because criminal.
Well, yeah.
Right. And there's so much depositions on the civil side, but in a criminal case, there's not usually a deposition. However,
right.
You could activate it by saying, the person's leaving. Right.
Yeah.
This investigator's going to China or wherever they're going. They're leaving the bureau, the whatever it is. Before you go, we're going to hold a deposition. Defense, you're going to be there so that we can use it for trial later. Yeah. I think that's absolutely a great idea that should be used.
We'll see.
All right, Dr. Vile, you've taken a backseat on this one. I haven't heard you not talk for a while. Like this. So are you just anticipating the next subject?
Well, that's one possibility. I was trying to look up, there was a First Amendment case decided yesterday, which is a little odd. The question is, a woman had circulated a petition against, a council member had circulated a petition against the city manager.
Right.
And she had been prosecuted. Well, she had been charged and actually spent a night in jail. The accusation was she had circulated a petition which was given to the mayor. And actually, the evidence to me looks at pretty good circumstantial evidence that she took it from the mayor without being authorized to do it. Again, the facts are still in dispute. But the question was, had anybody else ever been charged with that offense? And she looked at 218 similar cases in which people had not been charged.
So it was retaliatory.
It's a little bit like the rifle. It's a little bit like the gun case. She wasn't able to find a spot-on twin as to someone in her circumstance who had not been charged. And essentially, the court said that the court allowed it to proceed. I don't know that I think her chances are that good, but the court essentially said, if you can prove that, well, the example they gave was jaywalking. If you don't, if typically you give somebody a warning for jaywalking, and you give a ticket to someone because they call you a pig or whatever, if you're if there's an indication that charge or that prosecution is retaliatory, then that's arguably an interference with free speech rights.
And Chelsea, I think to answer your question, Dr. Vile, it's my understanding, so she was charged with some kind of obstruction, I believe.
Okay. That makes sense.
Later, I think it was dropped, but she was suing the council saying, you did that, you targeted me. You retaliated against me specifically to teach me a lesson.
Retaliated against her speech by pursuing this charge against her.
It was her petition, but...
by pursuing this charge against her and not other people who had done very similar things, if not exact twinsies, like our gun case, right?
Yeah, it's basically a selective prosecution argument. But because, Dr. Vile, what you're saying is there's this First Amendment element of, by offering a petition, writing is the same as speech for, oral speech, for if it's written, if it's spoken, whatever it is, that is a form of speech. And she's saying they're preventing me from speaking by arresting
retaliating against me because of my speech. Right.
Okay. And maybe this is because I didn't look at this one, I'll be perfectly honest, but this is my question, just hearing what you guys are explaining. Is that not with prosecutorial discretion is and it's not, they're not prevented from pursuing certain cases and not other ones? Is that not how the whole system is? Am I missing something?
Both of
y'all are smiling and laughing.
No, it's a good question.
That she's one of 241 or whatever, then that goes beyond prosecutorial discretion.
does it? Do we have somewhere that's
I mean,
if it was just 280, then no.
Okay, I guess, okay, yeah. And I'm like
And I
half
may
being
be
funny,
wrong
but
on the
half serious.
specific
Is
number
there
there,
something
too.
that like, because I really don't know the answer to this. Is there something that is like these like guardrails on this? Like, do we have anything like any sort of jurisprudence that offers some insight into this?
Yeah. It's
Not a
basically,
lot.
is it a retaliatory arrest?
Right.
Like
And so is this
arresting
like a
someone that you
content
would not-
focused free speech
and
issue,
she
right?
did spend it,
Yes.
she spent a night in jail, which if you're a city council person, that's probably not going to help you get reelected typically.
Well, and it's hard because I've had many defendants, some who were falsely accused, and they spent nights or sometimes a month in jail. And they're like, but this shouldn't have happened. And there's not much you can do about it. No, it shouldn't have happened. We got you out. It's great that you're out. It's great that they dropped the charges. And they're saying, but I shouldn't have been in there in the first place.
Right.
Why was I put in there? And for her, she's got that extra, but I wasn't just someone who was part of the process, who got caught up in the normal process. It smells fishy. It sounds like someone gave a call to the police department, said, you should go get this person. And ultimately, it left her off the council. She forfeited all rights on the council. So it seems...
I'm not sure about that. I think she just decided that she didn't want to be a part of it.
Right. But in either way, the result of what happened was to prevent her from speaking out, was to get her off the council. And I'm kind of behind her on this. Is do I want somebody targeting whoever they don't want on the other side? It's almost a Trump argument. I don't want to be... If the Biden administration is going to come after me just because my name is Trump, then I don't want any part of that either. It's that idea is, am I being targeted because I'm a certain person with the certain name,
right?
Or a Biden?
Biden's son. Yeah.
Exactly.
Right.
Or is it just, this is the normal process and I happen to be the person they were investigating in this case? Or I was so notorious that people couldn't help but see me or investigate me because my affairs are so public. But I think it's an interesting idea of a First Amendment case. And they didn't decide she was or was not exercising her First Amendment, but that she could proceed with the civil case.
So is that what the holding was in this? Is that
they basically remanded it for the Fifth Circuit, if I recall.
Yes.
okay?
Whatever circuit had basically said she didn't have a case, and they said yes, she does have a case.
She can use
She has
this
to
argument.
We'd have to. I mean, she might have a case.
Right.
I mean, I think I'm going to start trying to get the records of who's being pulled over and what their bumper stickers are then. And then we can start. I mean, are they retaliating against certain? I'm in Georgia. I mean, this pretty red state. I wonder, could we track if we're going to really do
put
it?
an anti-peach bumper sticker on and see what happens? Okay.
I think I'm get pulled over for speeding a lot more then.
And you could, but you would have to show that you're the only one, because I think in a way it's, well, everyone with this bumper sticker, they all targeted. Well, at least it's across the board. But if it's just you, it seems that would be different. So.
Okay.
Anyway, okay, Dr. Violet, let me mention real quick this immigration case, and we're not going to talk too much about it either. I encourage people to look it up on their own. None of us here do immigration law. But as I understand this particular case, a civil rights attorney actually was bringing this case, saying that the government didn't have a right they should have issued a visa to her husband, who's from El Salvador, that he was here in the United States, then he went back, and then he was trying to get a visa back in, and they refused it. And she's saying, look, this is impermissible because they claimed, or the idea was that his specific tattoos looked gang-related. And there was an allegation made through the process that he was either affiliated with or in the MS-13 gang, which is a very scary Hispanic gang, let's be honest. But from the facts that I could see, it appears that it was not just tattoos, that the tattoos did appear to be gang-related. There were certain symbols and words that could be said of this is gang-related. But in addition to that, there was an interview, an investigation. So there were multiple factors where in the end, the immigration authorities said, no, we're really worried about this guy. We do think that he's affiliated somehow with the gang. We are not going to permit him back in. And the wife said, that's unfair. You shouldn't be allowed to do that. You shouldn't be allowed to base it on his tattoos or whatever. He should have been allowed to stay. And ultimately, and Dr. Vile, correct me on this, but I think the ultimate decision was we're going to leave pretty much the decision in the hands of the immigration authorities. We're not going to tell them who they can and cannot admit into the United States. They have the ability to use whatever framework they have.
Given how fraught immigration issues are, that's probably a pretty wise decision right now.
Yeah.
There's been a couple developments there just within the last couple of weeks.
Yes.
Biden has introduced a plan similar to DACA, which essentially says if you're married to a U.S. citizen and you're in the United States, we're not going to make you return to your country and then return back before we give you a green card or citizenship or whatever it is. And an even more interesting development, as I understand it, is Trump has sort of issued this trial balloon, which says if you come to the United States and you get a degree, you ought to automatically get a green card. I think the notion is we want to keep the people who are educated here. They're the brains, they're the kind of immigrants we want.
But didn't we actually teach immigrants to fly the planes that flew into the towers? I mean, it's not a degree, but if we're,
well, I don't know that they had degrees. That's true. But yeah, I mean, I'm not. Yeah. I'm not introducing this for the truth of the matter, but merely that these are positions that the candidates have taken that are in some ways more similar than you might expect.
Yeah.
Each is sort of singling out a category of immigrants that they would permit as opposed to those that they would not.
Yeah, I think it's such a hard decision for immigration. I don't know how they process through as many as they do. Much less decide who is safe, quote unquote, to come in or not. So that's another one. Go investigate that one. And then let's talk a little bit then about, we want to make sure we talk about the special prosecutor issue with Jack Smith.
Okay.
And the 10 Commandments, baby.
And the 10 Commandments. Yeah. So let's talk about the 10 Commandments first. Chelsea, have you seen this new law?
I have. I thought it was a joke. I'm not going to lie to you.
Oh, really? You thought it was actually a joke?
I really did. And it's been a busy week for us in the office. And I happened to be laying in bed one night, scrolling through TikTok as you do. And I saw someone talking about it. And I thought it was like an Onion article that they were then making a video about, like it being a joke. To my dismay, the next morning when I decided to do a little Google search, it was indeed not a joke. And this is something that a state legislature thought was of utmost importance.
Yeah. So
what's fascinating about it is it goes further. I think it's Stone versus Graham, right? Which is
good. You've got the case name. If someone was going to have any case names, it was going to be you. Okay. So this other one.
There's a couple related, but I believe it's Stone versus Graham that had 20 years or so ago, had ruled that Kentucky could not post 10 Commandments in school classrooms.
Right.
Now, what's fascinating about this law is it also applies to college classrooms. And I cannot remember a similar sort of mandate, state mandate for colleges and universities. And I'm assuming, well, could they apply it to a private university? I'm assuming not.
No.
I'm not positive of that.
Right.
But what's fascinating about this case, I don't think it's a slam dunk.
But is it a case or is it just actually at this point a new law?
I don't think it's been challenged yet, but I think that is coming shortly, right?
Louisiana the governor just signed it a day or two ago.
Yeah.
Texas is contemplating a similar law. Wouldn't it all surprise me if Tennessee did? But here's what complicates
or Georgia.
Most of more of the southern states, right?
But this is insane, right? Can we this is crazy.
Well, let me make an argument that it's not as insane as you think.
This feels so crazy to me.
Tell us why it's not.
So, Stone versus Graham was decided largely on the basis of the lemon test. Does the law have a clear secular legislative purpose? Does it have the primary effect that neither advances nor restricts religion? And does it promote excessive entanglement? Well, the court has officially abandoned the established the Lemon test for a historic understanding. So if you were to go back and look at textbooks, for example, in most of American history, you look at the McGuffey Reader, Bible stories, all kinds of moralistic stories, and the like.
I think
what is consistent with, and as I guess I heard one of them arguing, we have one of the official mottos of the United States is "In God We Trust." You're not actually forcing someone to agree with it. Now, the tricky thing about the Ten Commandments is as you probably know, there's sometimes called the two tables, because the first part of the Ten Commandments relate to man's relationship to God, and the second half, most religions, I would think, would agree, against murder and theft and adultery and those kind of things. But it certainly has a theological component to it that is much more specific than the term "In God We Trust" or "One Nation under God."
It's a strong
but I'm not
Judaism.
sure, in light of this is a Kennedy decision where the court said that a public school teacher could pray on the 50th yard line after a game. I'm not sure if we don't use the Lemon test, if you use simply a historical test, and here's the problem, of course, which history do you use? If you use the history of the Virginia Statute for Religious Freedom, you can find some great quotations from Jefferson and Madison saying, high wall separation between church and state. It's not the state's business to go to West Virginia versus Barnett. No official high or low shall prescribe what shall be orthodox in religion and force others to do the same. This, of course, you're not actually forcing someone to affirm the Ten Commandments.
But you're forcing everybody to view them.
Yeah, and I think that's an endorsement, right? If I hang something on the wall or I put a flag outside of my house, as we talk about Supreme Court justice, I think that's very clear, like we're endorsing it, right? And the whole put no other gods before me bit, unless they want to put the rules for every other religion up on the wall, you'll get my vote on that one. But this seems very clearly
well,
a breach
again,
of this.
And that's the
But I do agree,
all
but
I'm
I will
saying
say,
is if your test is history.
No, I agree with what you're saying, though. If the test is history, this passes muster. I absolutely agree
Well,
with
I don't
that.
know that it passes muster.
I think it will. If we
complicated.
say we got to look at the historical thing,
But if we're looking at history,
I'm not hype
slavery's
about our history personally. I'm not trying to time travel back, but the justices seem pretty determined to do that. So I think it would pass that. If that's our standard, is there a historical precedent for this? I think that this law would be in the clear.
I don't like historical precedent because we're looking at Jim Crow laws. We're looking at slavery.
I'm from the South. If we're let's just revert to history, this is the least shocking thing that would happen, right? But the fact in 2024, the fact that this is happening in a state that has the bottom 10 education systems in our country, and this is their focus, it seems like a joke.
Yeah.
I cannot believe this.
Well, it's a form of symbolic politics.
Yeah.
Yes.
And we
it's for nothing.
We have a lot of symbolic. We have far more performers in Congress, in my judgment, show horses than we do workhorses. And the same thing happens at the state level. Now, that being said, I feel confident that some of the people who voted for this law genuinely believe, if people would just go back to the fundamentals, this would be a good thing.
Yeah, I think they're true believers too, but I think then they should go be a pastor and not a congressperson. I believe that they believe it.
Sure.
Absolutely. But maybe they're in the wrong career field then.
Well, maybe.
Yeah. And I have two thoughts on that. Is one, Chelsea, I'm very much aligned with your idea of, okay, well, then why isn't something else up there? What about the Quran? What about Napoleonic law? I mean, if we're looking at laws and fundamental, let's
put clips from the Torah up on the wall. Like, I don't.
Which this is, in a way, is, we hear
Yes,
Bible, but the Judaic rule is it's in the Torah with Moses. But
what about some Scientology? Can we put that up on the wall in the kindergarten classroom? I mean, I'm just saying.
So here's my question to Dr. Vile, is the reindeer case. You'll remember the name of it, but the manger and reindeer, right? What's this case? Because it feels like the inkling of the reindeer
Rhode Island
case.
versus something or another. Yeah.
The fact that you even know part of the name is amazing.
What's different, right? The reindeer rule basically said a state can have, if they have a Christmas display and they have a creche,
which is a manger
scene, then they can do it as long as it's not the sole focus. If it's in there with Rudolph and Santa Claus and snowflakes and the like, then it's just celebrating the season as a whole. But this case, I don't think actually fits that.
Really?
Because what most previous cases have done, the courthouse cases, for example,
with the 10 Commandments in the courthouse.
Well, right. Many of them have put up a whole display that includes like the Magna Carta and the Mayflower Compact and the 10 Commandments, and basically say these are our founding documents.
Which makes more sense to me.
Well, it makes some sense. But again, the inclusion of the 10 Commandments, I as much as I admire them and urge people to follow them, I don't think the 10 Commandments as such had a lot of influence, say, on the writing of the Constitution. I mean, it's not criminal law, for one thing. It's,
right. It does seem to be more of an advancement of a specific religion, more of an entanglement between state and religion.
It does, but again, you're using the language of the lemon test.
True.
And the court has said that we're not going to use the lemon test. But
I think that this is the thing. This whole idea that we should use historical precedent is absurd. Because, like, if we're throwing it back, right, like, Virginia and I would not be speaking on this podcast. I wouldn't be able to vote. Like, are we really going to say the historical precedent is how we want to move forward? Well, I know this is what they're saying the standard is, but I think it's absurd.
Well, you believe in historical precedent because you would gladly cite the 19th Amendment, right?
For the freedom of women.
You have the right to vote.
I think I would make more of the argument of, like, when they said men, they meant people. I think, to me, that's a better argument than the 19th Amendment. But
it didn't give women the right to vote prior to the adoption of the 19th Amendment, at least nationally.
True.
So it's not that we shouldn't consult history. It's that history there are a lot of conflicting precedents in history, just as there are in law, and it takes a very wise judge or justice to be able to pick through, which precedents are most important. And I honestly don't know how if you had asked me prior to Kennedy how the decision would go, I would say, well, it's clearly illegal. We got cases here. But, this is how people challenge laws, right?
Right.
States have the right to adopt laws that violate previous court decisions. I mean, if not, we would still be forcing people to salute the flag.
Yes.
Right? We had somebody continue to challenge that law even after it had been upheld.
Mm-hmm. Absolutely.
In the court. And so it's a fascinating case.
History is a fickle friend.
Yes.
All right, so let's talk about Amy. No, we're not going to talk about Amy Coney Barrett.
No.
We're going to leave that for another discussion about her and Thomas. Yes, we're going to talk about say the other name, Cannon.
Yes.
So the judge in the Florida documents case, the federal case against Trump, she's now making some interesting waves. Dr. Vile, what exactly is she suggesting?
Well, I don't know if she's suggesting so much as she's opening the court to 3 days of arguments. And by contrast, most people argue before the Supreme Court, they get half an hour per side. Maybe an hour if it's a really, consequential case. She's devoted 3 days of argument, at least one, and including amicus, including attorneys who don't have a direct interest other than, they have an opinion on this. as to whether Jack Smith was appropriately appointed as a special counsel. And this actually, it relates to Article 2, Section 2, provides for the appointment of Supreme Court justices, ambassadors, and whatever, with the advice and consent of the Senate. And then it says appointments otherwise not herein provided for, Congress may, by law, vest the appointment of such inferior officers as they think proper, and the president alone, and the courts of law, and the heads of departments. In this case, the Attorney General has appointed Jack Smith with the notion that he would be he himself, the government should not be prosecuting this case because he's part of the executive branch. And
So
my
does
understanding
she
is
think
we've
that
had
it's been
dozens of
violated?
special Pardon?
Does she think that this clause has been violated?
Well, she thinks, my understanding is yes. She thinks, well, I don't know what she thinks. She is allowing people to argue that this is not, that the position is so consequential that it should have been appointed by the president with the consent of the Senate, rather than as one of these inferior officers who can be appointed by heads of department.
But wouldn't that seem to make it more political if she left it to the president? Because that would have opened Biden for saying, let's go prosecute Trump.
Right. I mean, the purpose of the special
there
prosecutor was to put distance there. So, it would not be a vindicatory prosecution or, a politically motivated one. There have been questions certainly about, but most of the questions have been the other way. The questions have been, is there too much independence there? I don't think they're going to win on it. What's fascinating is that she's devoting so much of the case to this and to other what seem to be peripheral issues.
Well, let me ask you this.
Or not, she is allowing the delay of the prosecution to long after the presidential election.
Right. And so here's my question as a trial attorney, Dr. Weil, is did she make this independent question and bring it up and force the parties to argue it, or did the defense bring it up?
My understanding is that at least initially the defense did not. That amicus or somebody else sort of brought this out, and it's like, well, that's an interesting question. I really hesitate to question federal judges.
Yeah.
I know it's all the rage right now. What did Alito say to, somebody in private? What's this flag mean? That sort of thing. But, more than most judges, she's a relatively young, inexperienced judge. She's handling what could be one of the more consequential decisions, in this decade. And I think it just sort of underlines the concern that she may be in above her head. And I don't know if she is or not. I just, there's reporting in the New York Times that a couple senior justices sort of pulled her aside and said, why don't you hand this off to somebody with a little bit more experience? I think that's relatively odd. I don't think there are many times where judges counsel one another to avoid cases. But it will certainly be fascinating. And I haven't had a chance to see how the arguments are going this afternoon, but my understanding was that, several hours of arguments on this issue.
Chelsea, have you known of a case where a judge will independently bring this versus a motion being made? Does this, as another trial attorney, does this seem odd to you too?
Yes. And it made me have that feeling of like, do I not understand the procedures? Like, that's how I feel, because this seems weird. I mean, for lack of a better word, it just seems like that I haven't seen anything like this before. I mean, you can do it, but it's not really how people handle these things usually, and it feels off to me. Yeah.
It does. It feels like we're before the Supreme Court And normally the Supreme Court says, and Dr. Weil, you'll nod along with this, is they say we can only take up the issues that are before us.
Right.
Even if we think something
Case or
else,
controversy.
yeah,
Right.
even if we think something else was wrong in this case, no matter how bad we think the underlying case is, no matter how much we want to make a comment about other things that have happened, the only thing we can rule on is what was preserved for appeal, what the actual motions were by either party. And if they didn't make the motion, they didn't preserve it for appeal. So in my mind, I'm going back saying, but the parties, neither of the parties was asking this question.
Hey, maybe we've come full circle and they're just injecting some common sense into this now, right? Like we are just
maybe, but it definitely
it's the vibes.
She would certainly be on Trump's good list were he to become president, and she was the one who came up with a strategy for avoiding prosecution on this issue.
Next
Gotta play your cards. You gotta play your
Justice.
cards. I mean,
Yeah.
We've certainly seen a lot of members of Congress who are sycophants.
Yeah.
To
And
use a kindly term.
that's a
Pusillanimous sycophants.
go look that up, everybody. It's your vocabulary words for today. Yeah, it seems very much like it being a prosecutor or a defense attorney instead of a judge. It really seems to be inserting their authority into a case rather than being the neutral arbiter of the case is what it seems to be. And that's one of the reasons I don't like the idea of being a judge is I would get too involved and I'd be like, why aren't you arguing this? Argue this, dang it, and you'll do better. But the judges are supposed to be more neutral and supposed to listen to the arguments, make a decision on the arguments versus propose the arguments. So that's where it's hitting me a little bit wonky. But we'll see what happens. Stay tuned with us each week. We are in the heart and the end of the Supreme Court season. So this week we've talked about the decisions that came out for, and Dr. Vile's giving me the hold one more thought. What is that last issue for us?
We got debates next Thursday night.
Yes, and I guess we sort of mentioned it, but let's go back.
And this will be the only debates that have ever occurred between two people, both of whom have been president.
Okay.
like ever? Or like ever in recent history?
I mean, never in history.
Wow.
That's fun.
And they're to my knowledge, they're the earliest debates.
Right, which we talked about earlier.
Presidential debates that have taken place. And the rules are a little bit different. The mics are going to be apparently muted when an individual isn't supposed to be speaking.
Like that's going to stop Trump from screaming it from the rooftops. But whatever, go ahead.
Yeah. Well, it will be fascinating to see what happens.
We haven't seen Trump in a debate since the last Hillary Clinton, where he followed her around the stage.
Yep.
So,
well, no, he debated Biden.
oh, I guess that's true.
Yeah, he debated Biden.
I guess
because remember Biden said, "Oh, shut up" at one point.
That's right. That's
Oh,
right.
wait. Okay.
Okay.
Maybe I blacked that out.
It didn't seem as consequential.
I'm so over y'all. My first presidential election that I can vote in was the Trump Clinton, right? Like, so all of them have been a mess, and I'm really over it.
All of them have involved Trump for you. Yeah.
Yes. Yes.
So do you know that I'm going to date myself, but I got to, when I was probably third or fourth grade, I got to watch one of the Kennedy-Nixon debates with my grandmother.
Oh.
And they were the first televised presidential debates.
Wow.
So.
That's incredible. And your first...
I'm going to be thinking about that for a long time because, like, I understand logically how time works, but like perceptions of time periods,
Yeah.
I need to sit with that fact for a while.
I don't remember the Lincoln Douglas debates quite as well.
It's just a little farther
if
off.
that's any consolation.
You weren't there at the train cars.
Now, they were debates, by the way.
They were.
They would last hours, and
that's what people did is you would listen to.
One of the fascinating things about this debate is there aren't any crowds. There want to be no audience other than the television audience, and people. And I would think maybe this will help Biden because Trump, although I think Trump sometimes in a negative way feeds off crowds too.
Yeah,
he may say things a a little less discreetly than he would if the crowd weren't present. But
We love
that
some
will be
shock
interesting to
value,
see how
like-
that affects the dynamics.
Right.
Remember the debate between Trump and Clinton, where Trump brought in people who had been accused of having affairs with her husband.
Yes.
So presumably we won't have that kind of shenanigans.
One of my favorite.
I think we're
memories-
underestimating the creativity of people to create some shenanigans. At this point, I think the political arena in my entire adult life has been so absurd. I mean, we have C-SPAN being Bad Girls Club, talking about lash extensions and bad built butch bodies, and we have these presidential elections. Then I'm like, let's embrace it. Let's put them all in a house, Big Brother style, and just watch what happens. Like at this point, it seems like reality TV when we're calling them debates. I think 6 weeks in the Big Brother house, and we just watch, and then we vote. At this point, let's embrace the chaos.
The least realistic things on television is reality.
Reality TV.
Well,
That's an oxymoron, actually.
We already have a reality star running for president.
Yes.
There was The Apprentice. So we'll see what happens.
I'm gonna apply to be on his legal team and float this idea, guys. I might not be back next week.
Yeah. On that note, do watch the presidential debates. They will be before our next podcast. We may have to break the next podcast into several because if all of the last cases drop next week, we definitely want to take some more time with the more significant and most significant of those cases. But in the meantime, enjoy the rest of your week as we prepare for the last sessions and decisions from the Supreme Court. Enjoy the presidential debates as much as they can be enjoyed. Stay tuned to what's happening in Louisiana and catch us next time on the Legal Weekly Wine.